Hello, landlords. So what happens when a lease expires? Well, I mean, is it just, woo, throw it in the trash can? It has no effect. That's not true. And so a lot of times clients will come in and they'll tell me, well, there's not even a lease, so we don't have to worry about that. But that's not true. You'll find after a few questions, well, we used to have a lease. We signed a lease 3 years ago. It was a 2-year lease, and since then, we haven't had a lease. Well, here's how the courts treat that situation. The last signed lease remains the controlling document for the parties. Now, you may have modified the amount of rent that's owed, and whether you did that in writing or not is a different issue. But that last lease essentially controls what happens on the premises. So, for example, if the last lease was signed by Joe and Jonathan, so Joe and Jonathan are the tenants, but Joe leaves and Jonathan stays. Well, who is still liable under the terms of that lease? Both of them. Unless that lease was modified, the last signed lease controls. Now, you can have one tenant leave and then sign a new lease with the new tenant. Well, once that tenant leaves, he abandons his leasehold. And so if you decide to rewrite a lease where just one tenant is obligated, I mean, that's totally up to you. And that might work in your situation. But only with a rewrite do you get a change in the terms. And so what happens when you're filing an eviction and you file as though there is no lease, and then lo and behold, at the eviction trial, the tenant shows up with a lease, and that lease contradicts the things that are in your eviction petition? Well, bad things happen. So be conscious of the fact that just because the lease term has expired, that doesn't mean that the provisions, the other provisions in the lease, are not still controlling, especially if there are certain obligations that you owe the tenant that you haven't been supplying. And especially if those obligations affect the rent. And so you want to make sure that you always have an active written lease. That's the best way to do it. If you're going to have a tenant, have something in writing that is current and reflects what each of you is interested in maintaining in the tenancy. But if you've let the lease lapse, then, and for whatever reason you prefer a month-to-month tenancy, you can go on with that, but don't get rid of the lease. You may need it at a future date in order to enforce it. So remember, the last thing you signed, that's what controls. If you've signed 3 or 4 leases, you can get rid of the old ones, but the last one signed is the controlling document for purposes of disputes between landlords and tenants that are taken before either the justice court, county court, or district court in the state of Texas. All right, happy leasing.